Hello everyone. Am I audible to all of you? Please reply. Please reply that my audio and video is clear. This is my request to all of you, to all dear students. Please reply. Please make sure that my audio video is clear. Leave a message. After that, I'll start my class. Okay. Dear participants, my name is Ashish Rajbandhu, and today we are going to discuss about the important provisions of the Indian Penal Code. We will discuss about the historical background of the Indian Penal Code. And prior to the starting our topic, I would like to introduce myself that my name is Ashish Rajbandhu, and I am a faculty here, which is Pahujalaw Academy, as well as I am the guest lecturer in the Delhi University Law Center 1. Okay, so this is my brief introduction, and today we are going to discuss about the provisions of the Indian Penal Code 1860. Dear participants, make sure that I am audible to all of you. Please leave a message, that is enough, and after that I'll continue my topic. Okay, okay, thank you Jeet Singh. Thank you very much Jeet. Now we are going to start our topic. Dear participants, we are discussing about the Indian Penal Code. So first of all, we will start from the historical background of the Indian Penal Code. What is the history behind the Indian Penal Code? What was the reason of the inception of the Indian Penal Code? What was the main factors to introduce the Indian Penal Code? And who were the key framers of the Indian Penal Code? These are all the important issues which we are going to discuss. As I told you that the name of your statute, that is the Indian Penal Code 1860. What it means, dear student, dear participant? It means, when I ask it to you, what is the meaning of Indian Penal Code 1860? What is the meaning of 1860? What is the resemblance of the 1860? Many students told me that, sir, it means that Indian Penal Code come into existence on 1860. मैंने कहा okay answer है, that is okay. We will go with it. It means Indian Penal Code came into existence in 1860. Now I ask it to you, what was the situation prior to the 1860? What was the situation prior to the 1860? Dear student, on that time we were governed by the Britishers. And prior to the Britishers, we were governed by the Muslim rulers. Okay? During the period of 1860, the entire Indian subcontinent was ruled by the Britishers, and India is was also one of them. So I would like to tell you one thing. Prior to the 1860, there was no statute, there was no uniform penal code. If I would like to tell you one thing, that if I, Anuj, Jeet, and Naman Patel, there is 4 person. If I make a theft in UP and Jeet Singh committed theft in Bihar, Vansika committed theft in Bengal, and someone and Utkarsh committed theft in Maharashtra. So there is a 4 different state, and all the 4 people committed the theft. What it means, all the 4 people committed the theft irrespective of the place. All were dealt by the Indian Penal Code. All committed the offense mentioned in section 378, which is the theft, and we all the offenders punished by the section 379, irrespective of the place, UP, Bengal, Maharashtra, and other state. Irrespective of the place, all the offenders will punished by the Section 379. What it means? Now today, after the Indian Penal Code 1860, there is uniformity, there is similarity regarding the penal provisions. But this situation was not prevalent prior to the 1860, because there, on that time there was no Indian Penal Code. If on that time I, Utkarsh, Jeet and Vansika committed the theft prior to the 1860, suppose 1830, then there was no uniformity in the penal laws, there was no Indian Penal Code. It means all the four people governed by the different local laws, and there was no uniformity in the penal laws, and we were governed by the Britishers. That Britishers was ruling entire Indian subcontinent, and they were facing a huge problem that in the same part of the country there's a different laws. To remove this difficulty, to introduce the uniformity in the penal laws, there was need of the Indian Penal Code. So if I'll ask it to you, what was the reason behind the inception of the Indian Penal Code? The important reason behind this, to uniformity regarding the penal provisions. That was the reason. Look, Britishers was very sharp, very organized. They are not used to do anything in very hasty manner. First they planned, after that plant. Firstly they make a proper planning, and after that planting. So first of all, in the 1833 there was a Charter Act. Now we are going to discuss of the Indian Penal Code. Now we are going to discuss of the history of the Indian Penal Code. History of the Indian Penal Code is very important for the prelims point of view of judicial service examination. ठीक है? Governor General of India appointed a commission which was known as the Indian Law Commission 1834, and there was a Charter Act. There was a Charter Act 1833. In this Charter Act, it was recommended that there is a need of a commission for the recommendation of the law. So 1833, there was a Charter Act which recommended the first law commission in India. And just after the 1 year, Governor General Council of India appointed the commission, the Indian Law Commission, in 1834. So first law commission came into existence on 1834, just after the 1 year. Look, dear student, what is the date today? That is the 2nd July 2023. And we are talking about the 1833. Almost 190 year elapsed. Almost 190 year elapsed. 190 year. Dear student, this is the history. Our Indian Penal Code is not so young, but still it is prevalent and still it is effective. So now we are going to discuss about the history of the Indian Penal Code. I am telling you the first law commission came into existence 1834. And there was a member of there was a 4-member in this commission. Lord Macaulay, Sir Lord Thomas Babington Macaulay was the president of this commission, was the chairman of this commission. Sir Lord Thomas Babington Macaulay, Sir Lord Thomas Babington Macaulay, Lord Thomas Babington Macaulay, ठीक है? Macaulay. Lord Thomas Babington Macaulay was the president of the first law commission. There was 4-member. Number 2, MacLeod. Number 3, Millet. Number 4, Anderson. There was 4-member in the first law commission of the Indian Penal Code, commission for the Indian Penal Code. Lord Macaulay was the chairman of the first law commission. MacLeod, Anderson and Millet was all the other members. Lord Macaulay played a very significant role in the drafting of the Indian Penal Code. That's why Lord Macaulay known as the father of the Indian Penal Code. This it was the reason that Lord Macaulay is known as the father of the Indian Penal Code. Father of the Indian Penal Code. Lord Macaulay played a very significant role in the drafting of the Indian Penal Code. That's why he is known as the father of the Indian Penal Code. The first report, they made a first draft of the Indian Penal Code. First report of the Indian Penal Code was submitted in the 1937. After that, it was revised several times. And it was submitted to the Governor General Council in the 1856. Okay? And first time, Governor General of Council assented for the Indian Penal Code on the date of, it was assented on the 6th October 1860. It was the date on which Governor General in Council assented for the Indian Penal Code, and it came into force 1st January 1862 after the 2 years. It came into force. There is a two date of enactment and date of enforcement. Dear student, date of enactment is that date on which a particular act is enacted, and date of enforcement is the date of working of the act. So date of enforcement of the Indian Penal Code was 1st January 1862. It was the date. You may ask, dear student, this is the open session. You may ask whatever you want to ask. Okay? But now we are discussing about the historical background of the Indian Penal Code, and after that we will discuss about the important provisions of the essential ingredients of the crime, like mens rea, actus reus. What is the intention? What is the knowledge? What is the difference between the intention and knowledge? And what is the motive? This is the synopsis of this class. And now we are discussing about the historical background of the Indian Penal Code, because this is very important. I know Bare Act is the key of the success in the legal field, but you must know the history of the Indian Penal Code as well. Okay, so we were discussing about the provision that 1st January 1862 Indian Penal Code came into force. Indian Penal Code came into force, and Lord Sir James Thomas Babington Macaulay is known as the father of the Indian Penal Code. Okay, there is 511 sections. What I'm telling to you, there is 511 sections, and there is 23 chapters respectively. There is 23 chapters. Your Indian Penal Code is classified into the 23 chapters and 511 sections. 511 sections and 3 chapters, dear student. 3 chapters were added later on after the inception of the Indian Penal Code 1860. That is the chapter 5A of your IPC. That is the chapter 9A of your IPC. That is the chapter 20A of your IPC. That chapters were added later on. Chapter 5A, which is related to the criminal conspiracy, were added in the 1913. Chapter 9A, which is related to the offences relating to the elections, that is added in the year 1920. And chapter 20A, which is related to the cruelty by the husband or relative of the husband, inserted by the 1983. So it was the history. Dear student, we started our history from the 1833. Now 2023. Okay? Now 2023. IPC came into existence, in force 1st January 1862. On that time, this Indian Penal Code was applicable to the entire India. Entire India means including Pakistan and Bangladesh, because on that time there was no partition of this country. So this Indian Penal Code uniformly applicable to the Dhaka, uniformly applicable to the Islamabad, Lahore, as well as the Bombay. As well as the Bombay. After that, in the year 1947, India was the independent country and divided into the two dominant states, India and Pakistan. What Pakistan did with the penal laws, we don't know, don't care. But in respect of the Jammu and Kashmir, this Indian Penal Code was applicable to the entire India except Jammu and Kashmir, because Jammu and Kashmir were using different code known as the Ranveer Penal Code. Jammu and Kashmir was using the different code that is known as the Ranveer Penal Code. That is the Ranveer Penal Code. But in the year 2019, there was a huge changes. What were the changes? Would you please tell me? Please reply. What happened in 2019? And after 2019, not only the Indian Penal Code, many other acts now uniformly applicable to the Jammu and Kashmir. Many other acts now uniformly applicable to the Jammu and Kashmir. That is also very important. They are uniformly applicable to the Jammu and Kashmir. Kaise? How is it possible? Just because of the Jammu Kashmir enactment of the Jammu Kashmir Reorganization Act 2019. After the enactment of the Jammu Kashmir Reorganization Act 2019, after the enactment of the Jammu Kashmir Reorganization Act 2019, Indian Penal Code was uniformly applicable to the Jammu and Kashmir like the other part of the India. Not only the Indian Penal Code, but also the other acts like Indian Penal Code, Code of Criminal Procedure, Indian Evidence Act, Indian Contract Act, Sales of Goods Act, Partnership Act, that all such kind of acts applicable to the Jammu and Kashmir just because of the Jammu Kashmir Reorganization Act 2019. Don't use the word 370 because of the abolition of the 370. No. Don't give the answer that, sir, it is applicable to the Jammu and Kashmir because of the abrogation of the Article 370. No, don't give such kind of answer. You have to tell me that, sir, after the enactment of the Jammu Kashmir Reorganization Act 2019, all such kind of act applicable to the Jammu and Kashmir from the date of 31st October 2019. 2019, it was the history. So dear student, if we will discuss about the history of Indian Penal Code, today is the 2nd July 2023, and we are discussing the history from the 1833 to 2023. It is 190 year. This is the only act which has faced very less amendment. It means what I'm trying to say कि after the one history of the more than 150 year, Indian Penal Code is still effective, is still prevalent. This is very old statute and working in our country effectively. So it was the history of the Indian Penal Code. It was the reason behind the inception of the Indian Penal Code we were discussing. If there any doubt, if you want to ask anything, please ask. This is the open session, no doubt. If you have any query, dear student, please ask. If you have any query, please ask. If you have any query, please ask. Sir, now you are asking to me, sir, the name of the statute is the Indian Penal Code 1860. मैंने कहा yes. What is the purpose of this statute? मैंने I told you that the purpose of the Indian Penal Code to penalize. You said, sir, what for what? For the offense. So you asked to me, sir, what if the offense? What if the crime, sir? What if the meaning of crime? Many jurists have defined the crime in a different way. Look, listen to me. Crime is a very changing concept. Crime is very changing concept. Something is crime in one country and that is not a crime in another country. Like the France, adultery was no offense in that country, but in our country it was. But now it is repealed. It was removed. So what I'm telling to you, I'm telling to you that if crime is depend on these circumstances, state to state. Okay, so many jurists was trying to define the Indian Penal Code. Many jurists was trying to define the Indian Penal Code in a different manner. But Blackstone said crime is the violation of the public right and duties. Bentham said the crime is the violation of the public right and duties due to the whole committee. So if I will tell you what is the crime, crime is something which is prohibited by the law. If law prohibits you and you committed that thing, that is the crime. That is the crime. Stephen said about the crime that crime is an act which is forbidden by the law. Crime is an act which is forbidden by the law, which is at the same time revolting the moral sentiment of the society. Moral sentiment of the society. So I am telling to you, crime is the very diverse concept. It is vary from state to state, depend on the circumstances, like a language. Okay, so now I'm trying to say, what is the crime? Crime is something which is prohibited by the law. Which is prohibited by the law. Okay, so but now I'm coming to the different topic, elements of crime. Now we are going to discuss about the elements of crime. There is 4 elements of the crime. It is very important topic to understand the criminal law. Elements of crime. Dear student, I would like to tell you one thing very clear. There is 4 elements of the crime. There are 4 elements of the crime. Okay, there are 4 elements of the crime. Number 1, human being. Number 1, human being. Number 2, number 1, human being. Sir, now you are asking to me, sir, only human being can commit the crime. I said yes. Only and only human being can commit the crime. No one other than human being can commit the crime. Lion, dog, elephant, car, robot, nothing. Only and only human can commit the crime. So you said, sir, you are the human. Maine kaha, yes, I am. So are you the criminal? Maine kaha, no. I said there is 4 essential elements of the crime. I said there is 4 essential elements of the crime. Number 1, human being. Only human being can commit the crime. If a snake bites you and moves from that place, what happened? Is police going there to catch the snake for a proper trial? No. Because only human being can commit the crime. Only. So that's why there is 4 essential elements of the crime. Number 1, human being. Number 2, mens rea. Number 2, mens rea, which is guilty mind. Which is guilty mind. And number 3, first of all, human being, mens rea. To fulfill that mens rea, there is actus reus, which is the prohibited act. Number 3, actus reus. Third essential element is actus reus, which is prohibited act. Prohibited act. And number 4, injury. Injury to the society. What I was telling it to you, we are discussing about the elements of the crime. There is a 4 essential elements of the crime. Number 1, human being. Number 2, mens rea. Number 3, actus reus. Number 4, prohibited act. Number 1, we are discussing from the number 1. Only human can commit the crime. In European countries, initial stage, in the 15th century, in European countries, animals were also punished for the committing crime during the medieval era. But nowadays, after the inception of the principle of mens rea, criminal jurisprudence did not provide for the trial and punishment other than human being. Only a human under a legal obligation and capable of being punished can be a proper subject of the criminal law. What it means? A human being below the age of 7 years cannot commit the crime because he is duly incapable, unable to commit the crime. Okay? Only and only human being can commit the crime. Number 2, mens rea. This is very important. Now we are going to discuss what if the mens rea. What if the mens rea? This is very important. Now we are going to discuss about the mens rea. We will discuss mens rea, what if the mens rea, how it works. It is very important. Look, dear student, after the principle of the mens rea or the doctrine of the mens rea came into existence in the several countries, there is a phenomenal changes in the society. There is phenomenal changes in the society. Mens rea means guilty mind. What is the meaning of the mens rea? Mens rea means guilty mind. In entire Indian Penal Code, the word mens rea is not used anywhere. Mens rea means guilty mind, and it is denoted with the intention, knowledge, negligence, rashness, wrongful gain, wrongful loss, voluntarily, reason to believe, malified, etc. What it means? Entire Indian Penal Code not using the term mens rea. It's not using the term mens rea. Mens rea means guilty mind. It is the resemblance of the mental status. Mental status. Mental status. So we can say it denoted with the intention, knowledge, negligence, rashness, wrongful gain, wrongful loss, and voluntarily or reason to believe. That is all the example of the mens rea. Sir, what is the principle of the mens rea? Dear students, dear participants, the principle of mens rea is very small principle. What is the meaning of the principle of mens rea? Principle of mens rea is quite simple, but highly effective in the current scenario. There is only one maxim. There is only one maxim. That is the actus non facit. That there is only one maxim. That is actus non facit reum. Actus non facit reum nisi mens sit rea. Nisi mens sit rea. This is the principle of mens rea. The entire principle of mens rea based on the one Latin maxim, that is the actus non facit reum nisi mens sit rea. That's it. The entire principle of mens rea is based on one maxim, that is actus non facit reum nisi mens sit rea. You ask it to me, sir, this is the Latin phrase. How can we understand what is the meaning of this maxim? The meaning of this maxim is the act itself. What if the meaning of this maxim? Act itself does not make a man guilty. Act itself. What is the meaning of this maxim? What is the principle of mens rea? Act itself does not make a man guilty. Act itself does not make a man guilty unless the mind is also guilty. Unless the mind is also guilty. What is the meaning of this maxim? Look, the meaning of this maxim is actus non facit reum nisi mens rea. It means act itself does not make a man guilty unless and until his mind is not guilty. You commit anything, any offense, but you are not guilty unless your mind is guilty. You are asking, sir, please make it clear. I am telling it to you, this is an axe. Now I went to a forest and I wander here and there with all due care. I'm using the word all due care. I started cutting the tree. Suddenly, a boy came out from the shrub, and the iron of this axe thrown and hit that boy. I don't know that boy was hidden behind the shrub. What it means? That boy died due to the hit blow of this axe. What it means? I am the guilty? No. That boy dead, but I did nothing. Why? Because of me, that boy dead, but I did nothing. Why? Because there is a principle behind it, actus non facit reum nisi mens rea. What means act itself does not make a man guilty unless and until the mind is also guilty. There is no guilty mind. There is no intention to kill that person. There was no mens rea. That's why, despite the death of that boy, I am not committed any crime. This is the principle of the mens rea. This is the principle of the mens rea. But there is certain exception of this mens rea. Nowadays, this is the basic of the criminal law, entire the globe, not only the India. If you remove this maxim, your bare act of the Indian Penal Code is just a plain paper, nothing. Why so? Because it has the great significance. Entire Indian Penal Code, except some offenses, based on the principle of mens rea. Based on the principle of mens rea. Are you getting my point? So this is the rule. Okay? Is it clear? Dear student, if you want to ask something, feel free to ask anything. Okay? Dear participants, if you want to ask something, feel free to ask anything. Whatever you want to ask. If there is any query in your mind other than Indian Penal Code, other than this topic, you are all right to ask that topic. Okay? So dear participant, please remember this. Now I'm coming to our topic again. We are discussing about the Indian Penal Code. The rule is actus non facit reum nisi mens rea. It means the act itself does not make a man guilty unless and until the mind is also guilty. But there is some exceptions of this rule. There is some exceptions of this rule. What is the exceptions of this rule? Look, I am telling it to you. First of all, this was the principle. Now we are discussing the history of the Indian Penal Code. First of all, in 1789, in the year 1798, in the case of Fowler versus Paget, first time in the history of the history, in the year 1798, in the case of Fowler versus Paget, Justice Lord Kenyon first time said that for the commission of crime, there is the requirement of two things. Number one, mens rea plus actus reus. Mens rea plus actus reus is equal to offense. Mens rea means guilty mind, actus reus means prohibited act. To fulfill that guilty mind, is mens rea plus actus reus is equal to offense. First time in the case of 1798, in the case of Fowler versus Paget, Justice Lord Kenyon discussed about this principle. Okay, first time. And Justice Coke developed this principle. Okay, Justice Coke developed this case, this principle of mens rea. Okay, so there is two rule. Okay, actus non facit reum nisi mens rea has the rules which is applicable to the all the exceptions, but there is exception of this rule. There are certain cases in which there is no need of guilty mind. What I'm telling to you, there are certain cases. This is the rule. This is the rule. Okay, and there's also some exceptions. This is the rule. There is also some exceptions. There is also some exceptions. What are the exceptions? Exceptions means there are certain cases in which there is no need of the guilty mind. There is no need of the guilty mind. Look, always remember, if I'll apply this maxim, benefit for the accused. If I'll not apply this maxim, benefit for the prosecution. Benefit for the prosecution. So first of all, we are going to discuss what is the meaning of mens rea. Mens rea means guilty mind. Mens rea means guilty mind. Malified intention to commit a crime. Malified intention to commit a crime. Now we are discussing about the exceptions. Now we are going to discuss about the exceptions. Exceptions of the mens rea is known as the principle of strict liability. Principle of strict liability. This is the exception of the principle of mens rea. There is exception of the actus non facit reum nisi mens rea, which is known as the principle of strict liability. Strict liability. Look at me. Now focus on me. Look at me. Sometime offense even is constituted. Look at me. Sometime offense is constituted even without the guilty mind. Sometime, look at me, there's a rule that nothing is an offense which is done without the guilty mind. This is the rule of the principle of mens rea. As I told you earlier, that there is exception of this rule. The exception of this rule, exception of the rule of the mens rea is known as the strict liability. Strict principle of strict liability is just opposite to the mens rea. What if the exception of the principle of mens rea? What if the strict liability? Sometime offense is constituted. We are discussing about the strict liability, which is the exception of the mens rea, which is the just opposite of the mens rea. I am telling it to you that sometime offense is constituted even without the guilty mind. This is the strict liability. Sometime offense is constituted. Sometime offense is constituted even without the guilty mind. It is called the strict liability. There are certain exceptions. There are certain exceptions of the actus non facit reum nisi mens rea. These exceptions are as following. Number one, there is what it means. It means what I am telling it to you, in certain exceptions there is no need of any kind of mens rea, because these are all the exception of the principle of mens rea. It will come under the ambit of principle of strict liability. Number one, contempt of court. Contempt of court. Number two, kidnapping. Number three, rape. There is no requirement of the mens rea in these offenses. Only act can make you guilty. Bigamy, waging war, waging war. What it means? It means these are all the exceptions of the mens rea. Selling of a obscene book, selling of obscene book. Okay, selling of obscene book. Essential Commodities Act. Essential Commodities Act 1955. Dear student, you are riding your scooty. Listen to me. You are riding your scooty without helmet. Generally, you used to wear the helmet, but that day you forget the wear the helmet. Okay. You are riding your scooty. Policeman stopped you. Hey, come here. Where's your helmet? I'm going to punish you. Okay. Impose penalty on you. You are telling to the policeman, sir, a sir known as Mr. Ashish Rajbandhu was telling that nothing is an offense which is done without the guilty mind. So I daily used to wear the helmet. Today I forget, and my mind is not guilty. And without guilty mind, I am not a guilty. Policeman told it to you. That your teacher, which is known as the Ashish Rajbandhu, told you about the principle of mens rea. But you should look into the exception of the mens rea. Okay, there is some exception of the mens rea, which is known as the guilty mind, which doesn't require any kind of guilty mind. And your action, your act come under the act of the strict liability. So you are guilty, or he imposed a penalty on you. Why so? Because that act doesn't require any guilty mind, any kind of mens rea. So Essential Commodities Act. Next, Motor Vehicle Act. Motor Vehicle Act 1989. Motor Vehicle Act 1988. Foreign Exchange Regulation Act, many acts. So what I am telling to you, I am telling it to you that there is exception of the actus non facit reum nisi mensit rea, which is known as the strict liability. Sometime offense is constituted even without the guilty mind. There are certain exceptions of the principle of mens rea, like number 1, contempt of court, kidnapping, rape, bigamy, waging war, selling obscene book, Essential Commodities Act, Motor Vehicle Act. That is all the offenses. So, selling obscene book. Look, please make it clear with the help of case laws. Now we are going to discuss about the some case laws based on the mens rea. First of all, okay, first of all, I would like to discuss the cases which is based on the mens rea. First of all, there is case laws. I would like to tell the case Fowler versus Paget, Hobbs versus. Generally, I used to teach the principle of mens rea at least 3 classes, and I used to tell at least 20 cases. But today, with the lack of time, I would like to tell you the basic principle of the mens rea. Okay, basic principles of the mens rea. So now we are going to discuss about the cases related to the mens rea, which makes you clear what is the mens rea. Okay, so first of all, I would like to tell you the case which is known as the R versus Prince, Hobbs versus Winchester. There is several cases. Okay, so we were discussing about the principle of mens rea. It was the mens rea and it was the strict liability. Dear student, now I am going to tell you the difference of intention, knowledge and motive. Intention, knowledge and motive. Okay, what if the intention, what if the knowledge, and what is the motive? Always remember, this is the weak point, dear student. Generally you forget what if the motive, what if the intention, and what is the knowledge. Okay, now I am going to discuss what if the motive and what if the intention. Look, motive is the feeling. Now we are going to discuss what is the motive, what is the intention, and what is the knowledge. Okay, look, the way I am telling it to you, you will never forget it. Okay, so now I am going to tell you about the what is the motive, what is the intention, and what is the knowledge. But first of all, I would like to tell you some cases. Okay, the cases based on the principle of main rea. First of all, I will tell you one case from the main rea, one case from the exception of the main, which makes you clear. Okay, first of all, I am going to discuss the Seraz versus Rutjan. Seraz versus Rutjan case. Seraz versus D Rutjan. D Seraz versus D Rutjan. Okay, this is the very leading case. It will clear your concept of the mens rea. It will clear your concept of the mens rea. 1895, Judge Justice Wright. Justice Wright. Okay, what happened in this case? First of all, I would like to tell you the fact of this case. There is section 16 subclause 2 of the Licensing Act 1872, which prohibited the which prohibited a licensed particular liquor shop owner from supplying liquor to a policeman, on duty policeman. There is a law which prohibits to sell the liquor to a on duty policeman. Okay, it was held that in this case, the fact of this case, a policeman usually went to a liquor shop in a particular time. One day he visited that liquor shop during the office hour, and the shop owner provided the liquor. Okay, he was liable for that offense, violation of the liquor policy. Okay, trial for that offense. But in this case, Wright presumed that in the initial stage there was no guilty mind, because when policeman entered to the liquor shop, the dress of the policeman was not organized, badges was not there, and behavior of the policeman was like he is on duty. This was the reason to provide the liquor to the on duty policeman. So despite the prohibited act, there was no guilty mind. There was no guilty mind. That's why despite the prohibited act, there was no guilty mind. So that's why in this case, judge has absolved from the accused of that offenses, because nothing is an offense without the guilty mind. Nothing is an offense without the guilty mind. There was no guilty mind in the shop owner. That's why he was absolved. But now I am telling it to you a different case, which is known as the exception of the mens rea. Ranjit D. Udesi versus State of Maharashtra. Now I am telling it to you a case which is known as the Ranjit D. Udesi versus State of Maharashtra. This case of strict liability. Okay, after that case, I will tell you the difference between the motive and intention. What happened in this case? The name of the case is the Ranjit D. Udesi. Ranjit D. Udesi versus Ranjit D. Udesi. Ranjit D. Udesi versus State of Maharashtra. Okay. In this case, this case will make it clear what is the principle of mens rea and what is the strict liability. In the case of Seraz versus Rutjan, I was telling it to you what is the principle of mens rea, how it will apply. Without the guilty mind, you are not guilty. Okay. Now we are discussing about the Ranjit D. Udesi versus State of Maharashtra. In this case, Honorable Supreme Court, the date of judgment was the 1964 year. Okay, what was happened in this case? Honorable Supreme Court convicted a seller under section 292 of IPC. 292 of the IPC. Section 292 of the IPC. Seller convicted a person under the section 292 of the IPC. What happened in this case? There is a very interesting story. A book which is prohibited in this country, in our country, known Ladies Chatterjee's Lover Book. That was the obscene book, porn book, basically. Okay. So in this case, there was a book known as the Ladies Chatterjee's Lover Book, which was prohibited in India. Okay. And he was, Ranjit, selling that book, which was prohibited in India, although he had no knowledge about the book. So there is no guilty mind. But what I was telling it to you, that section 292 contempt of court, section 292, or selling obscene book is the come under the ambit of strict liability. So in the case of Ranjit D. Udesi versus State of Maharashtra, in this case, a man known Ranjit was selling the obscene book. Which was prohibited in India, known Lady Chatterjee's Lover Book. Court held that he is guilty of under section 292 of the IPC. Unlike he had no knowledge of this book, because act of the Ranjit come under the ambit of the strict liability, which is the exception of the principle of mens rea. In this case, offense constituted even without the guilty mind. So there is two contradicting opinion. One is the principle of mens rea, which is nothing is an offense without the guilty mind, and second is the strict liability, which is the exception of the mens rea, which says sometime offense is constituted even without the guilty mind. And your offense, Ranjit, which come under the section 292 of the IPC, that is the example of the principle of strict liability. That's why he is guilty for the selling obscene book under section 292 of the IPC, because in this case principle of strict liability was applied. Are you getting my point? Dear student, if you want to ask anything, please ask. If you want anything, ask anything, please ask. Now we are going to discuss. If there any doubt, please ask. What if the mens rea? What if the principle of mens rea? Please ask. If there any doubt, please ask. Jeet, Saloni, Anuj, Ziyan and other. Okay, if you want to ask something, please ask. Now I am going to tell you about the intention, knowledge and motive. Now I am going to tell you. Utkars, is there any doubt? If you want to ask something, please ask. Now I am going to tell you three things. Okay, always remember, because I know whenever I used to teach all these subjects, I found that there's a doubt in the mind of the students. That's why I'm telling it to you. Now I am going to tell you what is the intention, what is the knowledge, what is the motive. What is the intention, what is the motive, and what is the knowledge. Okay, all the terms which is the intention, motive and knowledge are quite similar. It seems quite similar, but there is a difference. Okay, there is difference. Always remember, what if the intention? There is requirement of the two element in the intention. There are two elements of the intention. There are two elements of the intention. Number one, there are two elements in intention. Number one, look, look. You are my student, I am teaching you, okay? Think in this way. Whenever I used to ask anything to you, anything ask it to you, you replied very badly. That's why there is malified intention in my mind against you. I want to kill you. Why I want to kill you? Because you disrespect me. Always listen to me. I'm telling it, what is the motive? Motive is the reason behind of your act. I want to kill you. Whenever you use the word why is the motive? This is the simple way answer. Why is the motive? I want to kill you. You said why? Because you disrespect me. So this is the motive. Neither the good nor the bad motive is relevant for the constituting an offense. Number one. An intention has two elements. Number one and number two. There is requirement of two things for the intention. Number one, desire of consequences. Desire of consequences. Desire of consequences. And number two, foresight. Number two, foresight of the consequences. Foresight of consequences. Number one, desire in my mind, and number two, foresight. Two element, desire plus foresight. Desire plus foresight. But in knowledge, look, this is a glass. This is a glass which is made from the glass. Okay, I left it. What is there is a knowledge that if I left this glass, it will break into the pieces. It was the knowledge. Look, it was the foresight of the consequences. I know the foresight. If I left this glass, it will break into the pieces. Okay, there is two element in the intention. Number one, desire of the consequences plus foresight of the consequences. Desire to break into the pieces. Foresight, if I left this glass, it will break into the pieces. Two elements required for the intention. But in the knowledge, there is only one element. That is the foresight of the consequences. Foresight of the consequences. Always remember, what is the difference between the intention and knowledge? Intention needs two elements: desire of the consequences, foresight of the consequences. This foresight of the consequences, I know if I left this glass, it will break into the pieces. It was the foresight, I know. And desire, I want it break into the pieces. Whenever two elements come together, that is the intention. Whenever there is only one element, that is the foresight of the consequences. Foresight of the consequences, I don't want to break into the pieces. I don't want to break into the pieces, but I know there is a foresight that if I left this glass, it will break into the pieces. There is foresight, so there is only one element, that is the foresight of the consequences. That is the knowledge. When there is desire, when there is a foresight of the consequences, that is the knowledge. If there is foresight of the consequences plus desire of the consequences, that is the intention. Look, I know you are a kid. If I will throw you from the 4th floor, I know the consequences, you will die. But what is this? If I am throwing you from the 4th floor, that is, I know foresight of the consequences that you will die. If I know There is a foresight that if I will throw you from the fourth floor, you will die. And there is the desire of the consequences. What if the consequences of your death? If there is desire of your consequences, I know if you will, I will throw you from the fourth floor, you will die. And I am throwing you with the desire your death. That is the intention. So there is two element in the desire of the consequences plus foresight of the consequences, and there is one element in the foresight of the consequences, knowledge. This is the difference. Whenever you use the word why, that is the motive. The motive, there is only one element which is known as the foresight of the consequences, that is the knowledge. There is two element, desire of the consequences plus foresight of the consequences, that is the intent, that is the intention. Number two, motive, neither good motive nor the bad motive is relevant for the constitute a offense. It is relevant under section 8 of the Indian Evidence Act. It is relevant under section 8 of the Indian Evidence Act. Motive means prompts a person to do something. Sometime offense is committed with motive, sometime without motive. Motive is the element which prompts someone to commit a offense. Is it clear? So, dear student, that's all for today. If you want to ask something, please ask. Okay? So, now time is over. We were discussing about the important aspect of the penal provisions. We were discussing about the important provisions of the Indian Penal Code. We will discuss about the history of the Indian Penal Code. We discuss about the mens rea. We discuss about the elements of crime. If you want to ask something, please ask. If you want to discuss about something, please discuss. That's all from my side for today. Okay? So my name is Ashish Raj Bandhu. I am teaching as a guest lecturer, the Law Center 1, Delhi University. Okay? And I completed my LLB and LLM from Delhi University. And this is very interactive session despite you are not replying. Okay? So if you want to ask something, please ask. Otherwise, I am going to wind up this session. If you have any doubt, any query, please ask. Any curiosity, if you want to know about the criminal law, please ask. Please participate. If you want to ask something, please ask. Okay? I will reply of all your queries. Okay? It was the webinar on the Indian Penal Code. And if you have any query, any doubt, please ask. Otherwise, I am going to wind up this session. Thank you so much. Thank you. Most welcome, dear. Thank you so much. That's all for today. Thank you. Take care. Bye bye. Thank you, Sarth. Thank you so much. Thank you, Chris, Augustine. Thank you so much. Thank you so much to all the participants for listening me carefully. Thank you so much. Take care. Bye bye. That's all for today from my side. Thank you so much, Rahul. Thank you so much. That's all from my side. You may leave. Thank you.